Hello everyone, and welcome to this webinar, the major changes to the World Anti-Doping Program, specifically focusing on how those changes affect athletes and what athletes need to know about those changes. Thank you for joining us from wherever you are in the world, and I hope that you're doing well, and we're going to try and keep you entertained for the next hour, and we'll run through what we believe are the major changes to the World Anti-Doping Program. And so my name is Ben Sandford. I'm the chair of the WADA Athlete Committee, and I'll be hosting this webinar for you today. And with me, I have Richard Young. Richard Young is a lawyer based in Colorado, and he's the lead drafter of the World Anti-Doping Code and has been numerous times, I think, Richard. Yeah. And we also have Marissa Sunio, who is a lawyer for WADA based in Montreal. So we're coming to you from North America and from New Zealand, where I am. Today we have over 500 participants registered for this webinar. And this is the second webinar in an athlete series that the WADA Athlete Committee is doing. The first one was COVID-19 in clean sport. And today you're here for the major changes to the World Anti-Doping Program. So again, thanks for joining us. I would encourage you to submit questions. There's a questions tab which should be showing, and any time you can ask questions, and we'll have a question and answer session at the end of our presentation, and that should be running for about 15 to 20 minutes. And we also have Salva from WADA, who is helping us on the technical side. So if you have any technical questions, you can also ask, and Salva will be asking those, answering those for you. Just to run through a little bit of, just before we get started, there's a WADA privacy policy. So this webinar will be recorded, and we will be making the recording available. WADA will not use personal information for any direct marketing or unsolicited follow-up unless you have first been informed and expressly consented to this. WADA will not share personal information to third parties, and also there will be a post-webinar survey which we would really appreciate if you would fill that out, and that will help us a lot. So the structure of this webinar is that we're going to briefly run through what the World Anti-Doping Program is and what the World Anti-Doping Code is. That we're then going to go over some of the major changes to the World Anti-Doping Code, changes that athletes have either been asking for or that will affect athletes. And then we're going to try and have a discussion amongst the three of us about some of those major changes. And then at the end, there'll be questions and answers. So to get everything started, Salva, if you can take us to the first slide. And Rich, I'll throw it over to you, and if you could take us through the history of the World Anti-Doping Code.
So let me take you back to the beginning, when the sports movement and governments got together back to form the World Anti-Doping Agency. The anti-doping rules that athletes had to follow around the world were a total dog's breakfast. For example, you could test positive for the same prohibited substance, and in one sport you'd get a 3-month ban, and in another sport you'd get a lifetime ban. The list of what constituted an anti-doping rule violation was different between sport and sport. The prohibited list of the IOC was different than the list that many countries had in their own laws. And so we had a situation where an athlete, young athlete, was competing in France. What she was taking was not banned by her sport, was not banned by her country, was not banned by the IOC, but it was on the French prohibited list. And so she found her name in L'Equipe as a doper. International federations and national anti-doping agencies would test the same athlete on the same day because there was no coordination. So from the athlete's point of view, this was a real mess. Coming up with harmonization of anti-doping rules was one of the initial and most important products of WADA. They put a small group of us together, a mix of outside experts and key people at WADA. And here was our process. Everybody sort of liked their own rules and wasn't inclined to change them, but recognized that harmonization was necessary. So what we ended up doing was talking to people and listening and listening and listening to try to come up with their best ideas and common approaches that most, if not everyone, could agree on. The first code drafting process took 2 years. We had close to 100 different internal drafts. We would circulate major drafts. I think we did 3 of them to stakeholders for comment. And the WADA Executive Committee was our steering group. And in a world conference in Copenhagen, the world agreed on the first anti-doping code. And this is what it looked like, kind of skinny. We told everybody at the time that, look, this is not our code, this is your code, these are your ideas. And there's going to be a number of things in here that you're not going to like. There's lots of things that you like, but there are going to be things you don't like, and there are things that aren't perfect. And so we're going to review this periodically. So 6 years later, we started the whole process again. Same kind of feedback, same kind of constant communication with people. And this is the code that went into effect in 2009. You can tell this is a well-worn document. 6 years later, we started the process again, and this is the code that went into effect in 2015. 2017, we went into the process again. I don't have this one in hard copy yet, but this is the code that we worked on from 2017 to 2019. And just to give you some facts and figures, there were 7 people on the team, 3 senior people from WADA, 4 outside people. We met with a couple hundred different groups or stakeholders, some governments, some athletes, some sporting organizations. We received more than 2,000 comments on the different drafts that we submitted, and ended up getting consensus on the document at the last World Conference in Katowice, Poland. Code goes into effect January 1, 2021. In the course of these 20 years of code drafting, we've talked to certainly well more than 1,000 athletes and athlete groups, but we'd never had an athlete on the code drafting team until this time around, and that was Ben. And that turned out to be a really good idea because on lots of different issues, it helped to have a guy in the room drafting, a person in the room drafting, who could bring a unique athlete's perspective. And so thank you, Ben. You made the code a lot better from the athlete's point of view. So that's the background. That's how we got to where we are. And this thing goes into effect January 1, 2021.
Thanks, Rich. Marissa, could you just take us through how the code sort of flows from being the code to how it actually affects anti-doping rules?
Sure.
And where we are at the moment.
Yeah, sure. So as Rich said, the code goes through a few rounds and getting comments, and the same happens for our international standards. So we have, we have 6, and we have 2 more that'll be brand new in 2021. That includes the International Standard for Education and the International Standard for Results Management. And so after the codes and the international standards are finalized, our WADA compliance team drafts model rules for the international federations, the national anti-doping organizations, and for major event organizations. And then these anti-doping organizations use these model rules to assist them in drafting their own anti-doping rules, which then apply to the athletes and athlete support personnel and any other members that may be under the jurisdiction of these anti-doping organizations. And the code does mention that some articles must be implemented in anti-doping organization rules without substantive change. So some of those things are the types of anti-doping rule violations, statute of limitations, and sanctions. And then for some other articles, there's a little bit of leeway to the ADOs to decide how to implement their own anti-doping program.
Thanks
That's
for
how
that.
it gets from WADA to the athlete.
Yeah, and so the slide that you're seeing at the moment, everyone, that's sort of the code is the core document. Then you have the international standards, and then we have the anti-doping rules that we all as athletes have to follow, which are implemented by our anti-doping organizations. Salva, can you take us through to the next slide? So we've been through this process of redrafting the code and redrafting the international standards and bringing in 2 new international standards. And I think there's a lot of really good changes in here for athletes. So there's changes that athletes have been asking for a while. And then there's sort of changes that have come about because we're going through the document and looking at it in more detail. So I just wanted to put, these definitely aren't all the changes that affect athletes. These are just some of the changes, some of what I would call the main changes that I think athletes need to be aware about in changing from the 2015 rules to the 2021 rules. So what we're seeing coming into force on the 1st of January next year are really big changes around substance of abuse. That's been a long-standing issue for athletes and for anti-doping organizations and their prosecution of that. Thresholds for common contaminants, again, like this has been an ongoing issue for athletes for a really long time, where they're taking a supplement, or even food these days, because the testing is so sensitive, and there's a common contaminant showing up there. And there's also the substances that athletes are taking out of competition, which are now showing up in competition. Forfeited prize money. So now under the 2021 code, forfeited prize money can come back to athletes instead of going to anti-doping organizations. So it's really going back to the athletes that are affected by anyone cheating and getting that prize money. And we also, one of the things that happens with drafting the code is it really reflects what's happening in the world and in anti-doping at that time. And obviously what's happened in Russia in recent years has had a huge impact. And so now we have whistleblower protections in the code. Another thing that's really big within athlete circles is athlete rights. And so we've specifically mentioned athlete rights in the code. And also we now have the Athletes Anti-Doping Rights Act. Then there's also been changes to protected persons. We now have recreational athletes. The definition for in competition has changed. There's some really big changes around result management and hearings. And I'm a big believer that the changes that are being made there are going to have a huge impact on how athletes move through a hearing and appeals process, and that will be very much for the betterment of athletes. There's also a new standard for education, and then we go on to things maybe where the rules have got more stricter, which is another thing, where we're asking for more flexibility in some places, but also stricter rules in other places. And so fraudulent conduct during hearings is now in there. There's additional persons caught by the code. So one of the grievances of athletes for a long time has been that we have all these documents which we have to follow, but other people working in anti-doping aren't necessarily caught by the same rules. So we have a big step forward there, where directors and employees of anti-doping organizations now have to follow the same rules that athletes have to follow. There's a change to prohibited association, which athletes need to be aware of, and also the rules around multiple violations has got a lot stricter as well. So I would say that's also a lot fairer. So those are just some of the major changes to the World Anti-Doping Code. So what we're going to do now is we're going to try and have a bit of a discussion around these changes, and we've put them into three broad categories. So the first one I'm going to throw to Rich to sort of walk us through, and we'll jump in and discuss them as we go. But over to you, Rich, for protecting against inadvertent doping.
Sure. So I don't think any of us have a lot of patience for real cheaters. The general view of athletes that we've heard over the years, not all, but most, would say that if somebody's a real cheater, they should not only get a lifetime ban, they should get a double lifetime ban, okay? But the code is strict liability, and there are situations where people commit an anti-doping rule violation, but they're not a real cheater. And so, I think we all do have some sympathy for that. And the original code was not very flexible. Imagine that you're trying to get all these cats in the same bag with their different sets of rules, and your concern is that they're going to go back to their own rules if you give them an opportunity to. So there was very little flexibility. Each time we've changed the code, we've added more flexibility. So here are the kinds of things that we've done to try to have a more fair approach to inadvertent doping. First, education. I mean, it's really sad when somebody commits an anti-doping rule violation because they don't know any better. So there comes in the international standard for education. And a significant part of that is making sure athletes know what is prohibited under the code. Second, we dealt with the issue of substances of abuse. So take cocaine. It's a powerful stimulant. In a speed sport, it can be a doping agent. But most of the time, what we see are situations where an athlete used cocaine in a social context well after the drug has left the athlete's system in terms of any physical effect. The metabolites are still in the urine, and that's a positive test in competition. And there were 4-year bans, there were 2-year bans, there were other bans that ended athletes' careers. We've done two things on that. One is we've created a category of substances of abuse, where if the athlete can show it was used out of competition unrelated to sport performance, flat 3-year period of ineligibility. If the athlete completes a satisfactory rehabilitation process, that can go down to 1 month. That is huge for athletes. It's also huge for anti-doping organizations because they're spending a ton of resources going to hearings over how long a sanction an athlete ought to get for a cocaine case, for example, instead of using those resources to go after the real cheaters. I'll finish this list and then I'm going to go back to Marissa, because in the substance of abuse category, we may have created some administrative problems for WADA that she'll get to work out. But I think this is a huge addition, and athletes and athlete groups were instrumental in making this change. It's something that we've tried to get into the code for 2009, 2015. Really happy it went in 2021. Thresholds for common contaminants. The best example I can give you of that is meat contamination with the prohibited anabolic steroid clenbuterol in Mexico, China, and Guatemala. It turns out that, and I'll use Mexico as an example, meat contamination with clenbuterol is pretty darn common. It wouldn't be a problem if our laboratories weren't so sophisticated and able to detect teeny tiny traces of the drug. But you can't tell what is the tail end of an excretion curve of the doping use of clenbuterol and what came from meat. The code was changed to allow very low levels of clenbuterol to be reported as an atypical finding, as opposed to just a straight positive test, so that the anti-doping organization could do an investigation to determine how likely it was to have come from meat contamination. You know, it may be that we can tell athletes that you shouldn't use risky looking nutritional supplements, and you do so at your own risk. It's just not fair to tell athletes in Mexico, yeah, you better be a vegetarian because you might get contaminated meat. Next is substances that are prohibited in competition only. But the problem is that you have tail end carryovers where it shows up in your sample in competition when you used it out of competition and it was not prohibited. And again, cocaine is an example. And so there's a special working group that's trying to figure out how you can identify whether at the time an athlete is tested, the cocaine metabolites in that athlete system have any potential to enhance performance and were taken out of competition. So the scientists are working on that. There's another working group that's dealing with diuretic contamination. They're diuretics that are pretty ubiquitous out there, like hydrochlorothiazide. It's traces of that seem to find their way into common products, including pharmaceuticals. So we're trying to come up with a reporting threshold so that if there's a trace amount, it's not likely to be the tail end of an excretion curve. It's more likely to be contamination, and so it just won't get reported. Same thing with meat contamination. We're exploring if there are other substances other than clenbuterol that we ought to look at. And Marissa, so I think the substance of abuse clause was a huge advance. We had questions about, well, wait a minute, how does the rehabilitation work and who approves and all of that. And our position from the code team, and I think the executive committee, was, look, this is an important change. Don't let perfect be the enemy of good. Yeah, there's some devil in those details, but this is an important change. Unfortunately, the devil in the details comes back into your court. So do you want to talk about that?
Thanks, Rich. So yeah, as Rich said, for the treatment programs, the code is giving the discretion to anti-doping organizations to determine what a legitimate and reputable treatment program would be in order to reduce a sanction from 3 months to 1 month. And for us at WADA and for ADOs as well, the substances of abuse is going to, really, I wouldn't say add work, but there still has to be proof, right, that the substances of abuse was used out of competition, that it was used, not to enhance sport performance. Although I don't think that has really changed from what it is now. And the treatment programs, again, so WADA will monitor, what comes in from ADOs, what's considered a treatment program. But for now, listen, we are letting the anti-doping organizations, or giving them the discretion for those treatment programs. And the substances of abuse will be included in the prohibited list, which will be out in October. So the long-awaited, the long-awaited disclosure of what's going to be on that list. As Rich had already brought up, cocaine will be on that list. So that's being finalized now. But I think for us as a results management perspective, I don't think it's going to change too much, as that's, like I said, that's already the type of proof we're looking for right now with substances that are used, that are claimed to be used out of competition and for non-sporting purposes, for recreational use. But now the difference really is just in the sanction. So we'll just continue to monitor that, and we're hoping that, this is, it goes in a positive way, and that it really helps the athletes and going forward.
Yeah, I think the substance of abuse and the changes there are really huge for athletes, because, as you said, Rich, what we've seen in the past is athletes taking these substances out of competition. They're not related to sport in any way, and then they're still showing up in samples, a week, 2 weeks later, and then we're having to ban athletes for lengthy periods of time. And yeah, it's created a situation, I think, which a lot of people and a lot of athletes feel is unfair, that we're here about sport, but we're not necessarily prosecuting people because of a sport advantage. The other one, like you said, is common contaminants and supplements and food. It's one thing to be taking a supplement and having that risk there, but it's a completely different thing when you're prescribed a prescription drug, or when you can't eat meat, or when you can't take a salt tablet or something because there might be a contaminant in that. So those are issues that have been around for a long time for athletes. So it's good that, I think it's really good that in the 2021 code that we're dealing with those. I just wanted to also mention the International Standard for Education. So from 2021, we'll have 8 international standards. The International Standard for Education, as we've already said, is one of the new ones. And this is a really good step forward, because we all realize how important education is, and how important education is so that athletes don't inadvertently dope. You need to be aware that there is a prohibited list. The prohibited list, is available on WADA's website, and there's a question that just came through on that. So, please look at the prohibited list. It comes out each year at the same time, and so it's athletes need to know what is on that list and need to be able to know their way around it. But education is one of the base things that athletes need to have. Like, we need to be educated about anti-doping, to know how to go through doping control, to know what we can and can't do. And the education standard will set sort of minimum standards around anti-doping organizations providing that education through education programs, and also setting up how they target different groups of athletes for different education. So that's a really good step forward for athletes as well. Was there anything else that either of you wanted to add on inadvertent doping?
I might add on that on the prohibited list. I mean, most of these substances have long chemical names that even I can't pronounce, but there are lots of hotlines available where you can say, I want to use, my doctor's given me this product. Here are the long chemical names that are in the product. Are any of those on the prohibited list? So you don't have to be a pharmacist to be able to avoid taking a prohibited substance. Just use the hotlines.
Yeah, and I would reiterate that because they're hugely helpful. And like Rich said, some of those names are horrendously complicated, and they're not always the same either. So please use those lines because they are invaluable. So moving on to another part of what has happened over the last year is what we've decided here to call filling in holes. And this is sort of holes that, as you go along and as things in the world happen, new situations arise, you realize that the rules that you have might need changing for those new situations. And so one of the first things, and as I said earlier, and coming out of Russia and also coming out of the fact that under the last code, the 2015 code, WADA was given powers to investigate, and that's hugely changed the landscape of anti-doping as well. And so now a lot of the prosecutions that we're seeing are actually coming about because of the investigations that anti-doping organizations are undertaking, and specifically that WADA is undertaking, and then handing that evidence over to anti-doping organizations for them to do the prosecution of. So that's been a really big step forward from 2015. But as part of that, anti-doping organizations don't really have much power to make people come forward. They don't have any power to sort of subpoena you or make you appear as a witness or anything. So they're really reliant on whistleblowers coming forward. And so, but there weren't really any protections for whistleblowers. And so the 2021 code implements protections for whistleblowers that do come forward, because we want people to be coming forward. We have the Speak Up line, which you can call or you can send emails in and report doping or suspicious activity to WADA or to your anti-doping organization. And we don't want people to be discouraged from this or for there to be retaliation against them. So in the new code, there's specifically clauses in there that means that anyone that acts against someone coming forward with information by either discouraging or retaliating can also be prosecuted for that. Rich, did you want to add to that at all?
No, I think that's great. I mean,
Okay.
it's funny if you think about the really big cases that have gripped our attention over the last 5 years. They haven't been positive tests. They've been Russia, they've been Armstrong, they've been Brunel. They're cases like that, which are not positive test cases. They're investigation cases, and witnesses have been critical.
Yeah, absolutely. So to all the athletes and other people listening to this call, please, if you see doping, come forward, and there's systems in place to enable that, and also now rules in place to help protect you. The second one on this one is fraudulent conduct in hearings and result management. And so one of the things that was happening was, someone was, there was allegedly an ADRV, they were going to a hearing, and then they were presenting fraudulent or false information in the hearing. And there seemed to be an increase in this. And so now we have rules in place which mean that this is not allowed, and that there's also consequences attached to providing fraudulent information in a hearing. Anyone want to add to that?
So I'll just say, one of the reasons an athlete would do that is because they're going to lose anyhow, right? They did it. And their only chance was to come up with forged documents and things like that, false testimony by third parties. And what's the downside? If I'm going to lose anyhow, why don't I try that? And now there is a downside. There's an extra sanction.
Yeah, and the other part of that is that the sanction for that adds on to the sanction that they will receive for the anti-doping rule violation that they've already committed. So, if they get 2 years for the first one, they'll also get they won't just serve 2 years, but they'll get an additional sanction for their fraudulent conduct as well.
Yep.
Additional persons caught by the code. And so in athlete discussions, this is one thing that's come up. I've been on the WADA athlete committee for 7 years now, and this is something that's come up a lot over the years, is that, you know, athletes feel like there's this huge weight and body of rules that we have to follow, but other persons in anti-doping don't necessarily have to follow the same rules as us. And that has created some annoyance with the system, but this is something that is now changing. And I guess one of the best examples of this is what happened previously in the IAAF, where you had, you know, persons basically had persons working in the IAAF who were hiding results, and, you know, athletes were getting off because of the fraudulent conduct of anti-doping officials. This also happened in Russia, and I think it's also allegedly, you might have to correct me on this, happened with the recent investigation with the IAAF, International Weightlifting Federation, but I think that's still an allegation and still being looked into. But essentially now we will have rules in place which mean that, you know, people working in these organizations that are dealing with anti-doping, whether they're board members, you know, whether they're directors, they're employees, or officers, they have to also follow the same anti-doping rules that athletes have to follow. And it's not that, you know, the anti-doping organization is going to go in there and do doping control and, you know, get samples off them, but, you know, if they're tampering or if they're complicit in doping, then now there's a way for them to be held accountable. So it's not just athletes, but also officials as well. So that's I think a really good step forward to make sure that the entire system is clean, or as clean as possible.
I'll add on to that, Ben. There have also been important suggestions in the overlap between government and sport organizations. The code can't tell governments what to do. They can only be bound by the UNESCO Convention on what they have to do. There's a whole section of the code that sets forth the stakeholders' expectations of governments. And so we're expecting government to have the same kind of rules in place for the people who are involved in sport in their governments, that if you're involved in doping athletes, you really shouldn't be holding a position in the Ministry of Sport. And if you want to cross over from the Ministry of Sport to a sport organization, that sport organization should not be hiring you. And if they find out that you've done something, they should let you go. Again, it isn't as clean as we would want it because we have to deal with employment laws and all of that, but it's a major step forward.
Yeah. Salva, can you please change to the next slide for us? Okay, so the next category of changes that we have is around fairness, and specifically fairness for athletes. So I just wanted to touch on a few things here. The first one is the definition of in competition. So if you're wanting to follow these in more detail, you can go to the WADA website and you can find the 2021 code on the WADA website. And if you scroll to the end of the code, you'll come to the definitions section. And there's some good stuff in the definitions, be that the definition of an athlete or the definition of in competition. And so, as you'll be aware, there is out of competition testing and there is in competition testing. And as Rich has already said before, there's different rules in play for when you get tested out of competition versus in competition. And so one of the things that always frustrated me as an athlete was depending on what competition I was in, there might be different in competition rules. So if I was competing, I was a skeleton athlete. So if I was competing in a World Cup event, my in competition started, I think at midnight the night before the competition and finished immediately after the race. If I was competing at the Olympics, then the entire 2 weeks of the Olympics was in competition, even though my race was essentially exactly the same as a World Championships. So you had to know what the rules were for the competition that you're in. And so the definition is now changed, so it harmonizes the in-competition definition across all sports. So it should hopefully make it easier for athletes. So it will now start at, if your competition is on a Friday, the in-competition rules will start at 11:59 the night before, and then finish once all the doping controls have been completed after that competition. The only ripple to this, and this is where we can probably add a bit of an exclamation mark, is that anti-doping organizations can apply, so your international federation could apply to WADA to change that if that definition doesn't work in their particular sport. Rich, is there a good example of a sport? Was it tennis?
Yeah, Sir Tennis. I mean, tennis would like to have their old, it starts with the first ball hit and it ends with the time you're out of the tournament. I mean, that is a legitimate ask on their part, but at least if WADA was going to approve that, if you're a tennis player, it would be the same rule. It would be a different rule than the standard in competition, but it would be the same rule whether you're playing an ATP event, a ITF event, or in the Olympics. So you as a luge athlete would have the same in competition rule wherever you are. It may be different than a track athlete, but you wouldn't have to bounce around and worry about, you know, whether you're in or out of competition.
Yeah. And off the top of my head, I want to say that the Olympics have now changed their in competition rule, so it's no longer the entire games, but it's dependent on your sports definition of in competition. I think I'm pretty sure about that, but everyone can go away and do homework on that. And they'll, I'm sure, announce their rules for Tokyo in due course. The next one I wanted to touch on was athlete rights, and so athlete rights are, you know, obviously incredibly important, and they've also become a really hot topic in recent years, which is really good to see. And so, in reflection of that, the code and its fundamental rationale now mentions as one of its points athlete rights. And there's also in the code one of the roles and responsibilities of WADA is to maintain the Athletes Anti-Doping Rights Act. And so the Athletes Anti-Doping Rights Act is a document that the WADA Athlete Committee has put together, and it's been approved by the WADA Executive Committee. And this document holds all your main rights that you have in anti-doping in one place. So again, like, please go to the WADA website, please find this. I think it's incredibly important that you know what your rights are within anti-doping, again, because we have lots of responsibilities and rules that we have to follow, but there are also rights that you have within anti-doping. So it's good to understand those and also understand where you can go for remedy and where you can go around compliance issues and so on. So we might talk about that a little bit more later as well. Forfeited prize money. So previously, forfeited prize money wouldn't go to athletes, which I always thought was a little bit strange. So now under the code, if, let's say, the person who wins the marathon wins $200,000, they get that $200,000, and it then is revealed that they have doped. then that money should be returned to the anti-doping organization, and that anti-doping organization is able to redistribute that to the athletes that should have received that money if it wasn't for that doped athlete. Of course, this becomes complicated because it's very difficult for anti-doping organizations to actually get that money back. But when they do, there is the ability for them, once it is recovered, to redistribute it. So hopefully what we'll see is the redistribution of prize money going back to the athletes that deserved it in the first place.
Editorial comment. Ben thought that was more than strange. He thought it was outrageous. And in the code project team, drafting team meetings, he insisted on that change, and we agreed that it was the right thing to do. So go ahead.
Yeah, thanks, Rich. And the next one is, so again, if we look at the definition sections of the code, we now have protected persons and we have recreational athletes. Marissa or Rich, do you want to go through protected persons?
Sure, Marissa, you can do that. I'll do it if you want, but.
Sure, I can take over it. I can take over on that. So a protected person goes beyond just, under the 2015 code, we had a definition of a minor, which we still have. And a protected person now covers an athlete that hasn't reached the age of 16 years old, or an athlete who hasn't reached 18, but has not ever competed in an international event in an open category, or is not included in a registered testing pool. So now it's not any minor under 18. There's now this caveat for, you know, a high level, international level minor athlete. And for other reasons than age, an athlete that's determined to lack legal capacity under national law.
Let me make a comment on that real quick.
Yeah.
It used to be that no matter how good, so minor athletes have special flexibility under the code in their sanctions and publication of their doping violations and things like that. And again, this was Ben's point. Wait a minute. If I have a 16 or 17-year-old athlete on the podium ahead of me at the Olympic Games, that athlete has had all the benefits of education, experience, and the like. They should be treated the same way as I am. And so I don't care if they're under 18. If they're 16 or 17, they ought to be treated the same way as everybody else if they really are elite and experienced. And so that's, again, where that change came from. Athlete's voice, you know, this is the way it ought to be.
Yeah, so to go on what Rich said, this new definition of protected person, you know, it broadens, you know, it helps athletes that are really, you know, maybe, you know, under the age of 16, don't have the access to anti-doping education, and then also puts the responsibility on these high-level minor athletes that are competing at, you know, world championships or, you know, the Olympic Games, that should have access to, you know, all the education and resources as another elite athlete over the age of 18. So that's protected person. I don't know if you want to go into the how the sanctioning works for protected athletes specifically, or if we leave that for another.
Yeah, we can.
I think it's an important distinction, and there's more flexibility in sanctioning.
Yeah.
And the same would be true with recreational athletes. Again, as Marissa said, because they typically don't have the same opportunities for education, experience, and the like.
Yeah, so with recreational athletes, so recreational athletes are now defined in the code, and this was a really big category, you know, of athletes, and there's been lots of stories over the years about, you know, you know, someone's father who's competing in some marathon, let's say the New York Marathon, and they're definitely not a high performance athlete. They're just out there to, you know, finish the race, and they get tested, and you know, then suddenly the full force of all the anti-doping rules comes down on top of them. And so for athletes and also for anti-doping organizations, there was this desire to have a special group of athletes that are that we define as recreational athletes. And so now that's up to your anti-doping organization to define, you know, what is a recreational athlete. But there are certain limitations on that definition. So they can't have, I think, competed internationally in the last 5 years, and they can't have been in a registered testing pool within the last 5 years. And so there's this new category there. Anything to add on that one?
Very, very quick. Your example of someone's father tests positive in a marathon. So he tests positive, and he tests positive for marijuana. The normal rule is that anti-doping rule violations are publicly announced. Well, guess what? It's announced, and he loses his job as an accountant. For recreational athletes, the requirement of publication is not there. Again, fairness.
Yeah. Next one is national level appeals and the new ISRM, which is short for International Standard for Result Management. And so I think this is a really big change, and I think us now having an international standard for result management, so this is the document that sets out how hearings and how appeals should be held, is actually a really big step forward. And so previously, one of the things that we were seeing is that an athlete would be investigated, they would be prosecuted, and then the decision maker would basically be one and the same person or body. And so there was no separation of power in that situation. So as an athlete, the person that investigated you, you would then have to appear in front of them and plead your case, and then they would make a decision against you, or probably against you in that situation. And this has been really common. And I would definitely say that's not best practice. And there have been organizations that have moved away from this, which has been a really good thing. But now it's mandated through the code and through the international standard for result management. And I've written something down here. So I think it's probably important just on this point. So in 2015, under the last code, if you had allegedly committed an anti-doping rule violation and you went to a hearing, the hearing only had to be impartial. And then if you appealed that as a national level athlete, the appeal body only had to be impartial and independent. And so now under the 2021 code, that first hearing has to be impartial, and that hearing panel has to be operationally independent. And then your appeal has to be fair, impartial, operationally independent, and institutionally independent. And that makes a massive change, especially on appeal, I think, for national level athletes. So if you're an international level athlete, you always had the ability to go to the CAS, to the Court of Arbitration for Sport. But for national level athletes in the majority of countries around the world, this didn't exist. And so it's going to be a really big change for the hearing panels and how they work, and also where anti-doping organizations hear those hearings. Does anyone want to add to these changes?
No, you nailed it. When we first started this code process, rather than try to mandate uniform results management, we said you can use the old system you're using. It just has to meet basic safeguards. A lot of organizations did meet those basic safeguards. a number didn't. And so, okay, fine, we're far enough down the road, we're going to have an international standard and set the bar high that you have to meet or you're not in compliance.
Yeah, I agree. Having this standard for results management is really helpful, I think, for us at WADA and for ADOs to ensure that this high level is being met, and it also gives an outlet to ensure that compliance is being met when it comes to these first instance and second instance panels. And as Ben keeps saying, which is great, if you in the definitions section of the code at the end, there are definitions for operational independence and institutional independence, if any of the athletes are interested. And we know by our WADA compliance team, as they start to review the anti-doping rules, as we discussed earlier in this webinar, is to ensure that the rules do reflect that the operational independence it's now in the rules, and if a national anti-doping organization chooses to have a national appellate body, that it also is now institutional, and we know that ADOs are working to ensure that they can meet the standard in 2021.
Yeah. And the last point on the fairness was multiple violations. And so this is probably fairness flipped the other way around. And so previously to us starting the work on redrafting the code for 2021, there were a couple of situations that came up around athletes and the multiple violation anti-doping rule violation. And so essentially what was happening, and this has really come to the fore because we're retesting samples from so long ago. And so what would happen is that let's say I got caught for doping last year, and I'm going through the hearing process, and then they retest my sample from the 2014 Winter Olympics. Because that notification is after I've been through this process, after I've been notified of what would technically be my second doping offence, then it would essentially get combined into the same offence instead of two separate instances of doping. And so then you had athletes that probably should be being banned for a lot longer, actually only serving one ban when they're done, doping, let's say, at 2 Olympics and not just 1 Olympic. So that rule is now a lot stronger. So now if, the anti-doping organization can show that these were 2 separate events, it doesn't matter when that notification comes in, you can still be charged separately for both of them. So stricter rules around that, which is really good when we're retesting samples from so long ago. Anything to add on that one?
No, good.
No, good. Okay. So that wraps up our discussion, and we're getting to the hour mark here. So I'll see if there's any questions that have come in that we can try and answer. Have either of you seen any questions that you think we need to answer? So there was a question about how does prize money redistribution work? And that is going to be up to the anti-doping organization, which gets the money. So my hope would be that it's relatively straightforward, but I know that in some sports, let's say tennis, it can get really complicated as it sort of aggregates its way down through the playing field. There was another question on prize money about how anti-doping organizations will go about collecting prize money, and that is one of the weaknesses, that if the prize money has already been paid out, it's difficult for the anti-doping organization to get that money back. I always remember there was a situation, I think, of a marathon runner who won some prize money, went back to his home country and got himself declared dead, and is now living in the mountains with a changed name, just so he didn't have to pay back the prize money. Thought that was a rather, extreme length to go to.
So Ben, the anti-doping organization is not required to go sue and chase athletes to try to collect. But usually what they do is they say, you're not going to come back and compete in any of our events until you pay the prize money. That's usually the collection tool. And then it gets redistributed to the other athletes. If the athlete retires and goes into the mountains with the money, there's really not much you can do.
Yeah, and the other thing is that there's nothing in the code preventing athletes from also suing for that money. And I've always been surprised that that hasn't actually happened more, but it is a possibility. And maybe with the changes in these rules, and we might see more athletes pursuing getting that prize money, especially in some sports where the prize money can be quite big. There's a question, why is the definition of who a recreational athlete is up to the NADO to decide? Rich, do you want to have a go at that one?
Well, the NATO said that we ought to decide, and the International Federation said that they ought to decide. And no surprise there. we needed one definition so that the poor devil could know whether he was a recreational athlete or not. And if you balance between the International Federation's interest and the national organization's interest, recreational athletes are really more at the national level. They will be the ones that they're not going to be competing in the world championships, that's for damn sure. But will they be competing in major regional events? Will they be competing in national championships? Has the National Anti-Doping Organization's program of education reached them? Well, who knows that best? It's really the National Anti-Doping Organization. So that's why that is left to the NATO, not the IF.
Another question here is, were there any proposed changes that didn't make it into the new code? And if so, what and why?
I'll leave that to both of you.
About 1 million.
yeah, a lot.
I mean, about 1 million. I mean, we did get over 2,000 comments. Okay, so some of them were not good ideas. That's why they're not in there. Other ones we just couldn't come close to a consensus on. I can tell you that all the good ideas that we could come close to a consensus on, we pushed. And most of those got in. We would have had tougher language on what sports and governments, what sports were required to do, what governments had to do in the way of making non-athlete support personnel responsible, but couldn't get consensus on all of that. We got consensus on a lot of that, but not on all of it. But just lots of different things. Some people wanted longer sanctions. Some people wanted even more flexibility in the area of substances of abuse. And I have a list. It's in purple on this document of comments that deserve to be brought up again for the 2027 code. Was that your experience, Ben?
Yeah, absolutely. And that's something else I would add is, and I think you can see this as we've been talking about this code compared to previous codes, is that it's it's constantly evolving. constantly trying to make improvements to it. It's constantly adapting to, you know, new situations that are coming up within anti-doping in the world and sport. And so one of the things that actually struck me through the code drafting process was there are a lot of, I would say, like good ideas that would work like regionally or within specific countries. But then when you actually tried to make that work in a code that was applying around the world, it was just often not possible. And so it's a code that applies to the world, and so you need good ideas that can actually be implemented around the world. I mean, one of our questions here is, do you have officials that travel around the world keeping up the standards? And they're definitely not traveling around the world at the moment, but WADA has a full compliance team, and so once the rules are in place, that then becomes a compliance issue, and WADA makes sure that, and Marissa, I think you're probably going through this process at the moment where anti-doping organizations are changing their rules and sending them in to you to approve them. Is that where we are at the moment?
Yeah, that's accurate. So it's been keeping our compliance team very busy, as each ADO, so international federations and national anti-doping organizations and NOCs that act as NADOs, all sending in their rules for review. Yeah, so 2021, just based on this webinar, there's a lot of changes. So just to ensure that everyone's rules are harmonized.
Yeah, and then the compliance it doesn't just stop at an organization having those rules, it's ongoing. So yeah, they need to, like we said before, they need to have the correct hearing structure and independence and so on. And
there's a whole process. So we do continuous monitoring, we do audits of anti-doping organizations, which were in person up until COVID. So now WADA is trying to restructure to ensure that we're still conducting those audits and still ensuring that we're monitoring ADOs. And then of course, just with ADOs implementing their anti-doping program is also where, we might see, a pattern of non-conformities, and that's how we can address and work with these ADOs to ensure that, their program is brought back up to the standard required by the code and the international standards.
I've always thought the compliance was one of the hardest and most important parts of WADA's job. In the very early days of WADA, compliance was largely do your rules follow the code, and have you had a major screw up that requires WADA's intervention? And now there's active monitoring of whether you're, walking, not just talking the talk, but walking the walk in terms of following the code rules. Our job, but critically important to the way the system works.
Another question that we should briefly answer, and then we'll wrap this up, is do athletes have any rights over the other use of their body fluid samples for other forms of testing? I'll briefly say something on that and then maybe flick it to you, Rich. I think it's important to say that if an organization was going to do any other testing on your sample, then they would need to have rules in place for that. Maybe someone's calling you to ask you the same question, Rich.
Don't answer that. Sure.
You got the same problem.
Go ahead.
So I think, who was it? Was it one of the anti-doping organizations I saw in the media just this week? Is it Ski that's going to sample for COVID as well? Oh, someone's also using they've put rules in place, I think, and they're going to use the samples that they collect to test for COVID-19 as well. I forget who that is, but I'll throw this one to you, Rich.
Okay. So the only thing that you can have an anti-doping rule violation for is a prohibited substance. So for marijuana and cocaine, you don't test for those in out of competition tests and end up with positive tests, okay? A number of organizations have said, look, we have a code of conduct which prohibits the use of cocaine at any time. Do we really have to go interfere with the athlete's life? And we have a right, and under our rules, we have a right to collect samples from them to test for cocaine at any time. If they want to be in our sport, that's part of the deal. Do we really have to do separate collections and interfere with the athletes twice on the collection process? And as long as we do, we'll do the same collection. It will have nothing to do with whether it's a doping violation. It will have to do with whether it's a code of conduct issue. The other that has been discussed is part of the gender testing. Part of the gender testing is multiple tests of testosterone, serum testosterone. And if the blood is being collected anyhow, has nothing to do with a doping violation, but why not allow, if your rules provide for it, and if the athlete is required under your rules to provide blood for purposes of testosterone levels, why not do it in a single collection? And you hit the key point right off, that the organization's rules have to provide for it and require it. And then the question is whether it's simply one collection or two collections.
Thanks, Rich. I think that probably, sorry, there's a number of questions which we haven't had time to come to, but I will endeavour to write to you if you've sent in a question in the coming weeks and answer those questions as best I can. But thank you very much to everyone who's tuned in to this webinar. I hope you found it useful and informative, and we will have further athlete webinars coming up in the future, so please tune in to those as well. You had my details, my email address, and also WADA's legal team, their email address there. So if you have any specific questions, please contact us and we'd be happy to answer. Please go to the WADA website. There's lots of information on there as well. And also this has been recorded and the recording will be made available to you as well. And finally, just a huge thank you to Richard Young and Marissa Sunio. Thank you so much for the discussions and helping out and all the good explanations today. And to everyone out there, please fill in the questionnaire. I think that'll pop up once the webinar finishes. So wherever you are in the world, thank you very much and hope you stay safe and well, and we'll talk soon. Thanks everyone.
Bye-bye.
Bye. Bye.